All right, let's go back now to our earlier conversation. The National Prosecuting Authority has welcomed the Johannesburg High Court's decision to dismiss the controversial businessman Vusimuzi Cat Matlala's bail appeal. The businessman stands accused of being the mastermind behind the assassination attempt of his former partner, Tebogo Thobejane, in October 2023. Let's welcome legal analyst Mpumelelo Zikalala again. Mpumelelo, let me pose that question again. So both the Alexandra Magistrates Court and now the High Court have found that Matlala's release would not be in the interest of justice. From a legal standpoint, what does the Johannesburg High Court's decision to deny him bail signal just about the strength of the case against him?
Apologies about that. It basically says the case that you have against you is very strong. It then says you have failed to convince us as a court that it is in the interest of justice that you must be released on bail. Remember that the onus and bail application based on the accused person to say, if you're going to release me, I'm not going to interfere with any evidence. I don't even know the witnesses that are there. I'll make sure that it's the interest of justice that I stay away from whatever investigations are taking place. But in this case, what you saw is someone having two passports, reflecting one, as we've heard from the NPA, that is still outside the country. Then if you're not truthful in your outcoming and being open about the status of your matter, then certainly the court is going to say you have failed to convince us that you are indeed deserving to be released on bail. Another thing which is important to remember is that once you've started within the magistrate court, if you move on to the High Court, the record can be augmented, or there's nothing else that you can be able to add. Information that you provided earlier, which will be on record, which is what the court would use to assess whether you should be released on bail or not.
As we heard from the police earlier, just following this particular decision, I mean, we heard from the police that they're also looking at other violent cases against him. Does Matlala have any further legal recourse, for example, appealing to a higher court? I know you're starting to respond to that, or even filing for a review, and just the factors, the factors that would make such an appeal viable or even unlikely to succeed at this point in time?
Yes, there's still that option. Remember, the Supreme Court of Appeals is still there in terms of appealing, even if you feel that the Constitutional Court is still available for you to go there. But the difference between the appeal and the review, within the review, I are then saying there are certain procedural irregularities that have taken place. There are instances in which I wasn't allowed to provide evidence. There are instances in which procedurally there might have been things that did not go according to plan, according to how the Criminal Procedure Act states they should be. Only then a review application would succeed. But his only option that is there now is to then say, I want to apply to the SCA, or another option would be to say, I have new facts. Can I make an application, a new application based on new facts, and I'll start within the magistrate court and provide the new information which is now available, which was not available then when I made my earlier application.
I'm hoping that this line will hold. Let me ask you this again in terms of Matlala's arguments. He's arguing that he has been cooperating with, the powers that be, and he is not a flight risk. How does a court then balance such claims against the prosecution's argument that his release could endanger witnesses and even investigators?
Well, in terms of endangering, you simply have to provide information to say, I will stay away from where they are. Or the most important one is that I don't even know the content of the investigation and how the investigation is. And then give the assurance that whatever conditions which are going to be applied, I'm going to stick to them. And I'm not going to make anything which may jeopardize the investigation as it is going on. Now, with regards to being a flight risk, if you are not forthcoming and say, these are the travel documents that I have, this is the properties in which I have, this is the places in which I can be able to go to, that's when you're going to have a problem in trying to convince the court that you're not going to abscond and not come back. The fact that you are a first-time offender does count for you, but it is not the only thing which is looked at by the court. So the rule of thumb, or the most important rule, is disclose the information accurately. Make sure that you don't leave anything out, even though it is against It has been stated, evading that is easy. But if you fail to do that, especially within the magistrate court, even if you go in appeal, you go on an appeal limping because still information has not been provided to the court, and for a lack of a better word, you have misled the court into thinking that you're a truthful person when you are not.
Mpumelelo, thank you so much for your time. And again, apologies, of course, to you and our viewers for that sound. That was legal analyst Mpumelelo Zikalala just responding there, of course, to the Johannesburg High Court dismissing the controversial businessman Vusimuzi Cat Matlala's bail appeal.